We have a phenomenal panel here of four really interesting people to talk about federal psychedelic rescheduling and the impact on state law. So I'm going to kick us off with just a very brief overview. This is a super complicated topic, and there are a lot of different facets that we're going to be touching on for this. And my job here is going to be to guide this conversation. I'll also be monitoring the chat in case anybody has any questions throughout. And hopefully giving you just a very, very brief overview to get you up to speed, because I know we probably have several non-legal folks on the call, and we want to make this as user-friendly as possible. So first, I'll just introduce everyone. I am Vince Strallman. I am the director of the Life Sciences Law and Policy Center here at BCLT at Berkeley Law. And one of my big passions is psychedelic law, and really excited to kick off a lot of our programming for that. Next, I have Ismail Ali. Ismail serves as the co-executive director of MAPS. He has been actively participating in drug policy reform movement for over a decade, informed by half a lifetime of diverse personal experience with psychedelics and other substances. Previously, as the director of policy and advocacy at MAP, Ismail supported the design, advancement, and implementation of psychedelic policy reform across the country and world. Ismail co-founded and co-chaired the board of the Psychedelics Bar Association and is licensed to practice law in the state of California. Next, I have Graham Pachenik. Graham Pachenik is a registered patent attorney and the founder of Calyx Law, a firm specializing in intellectual property for cannabis and psychedelics ventures. He serves on the board of directors of the Psychedelic Bar Association, is editor-at-large at Psychedelic Alpha, and works with the UC Berkeley Center for the Science of Psychedelics on tracking federal and state developments in psychedelic regulation and policy. And I'll just give a shout out to our friends at BCSP. If you're interested in learning more about psychedelics, I highly recommend looking into their programming. Next, I have Shaheen Shams. As a data scientist and patent analyst at Porta Sophia, a nonprofit public benefit organization dedicated to protecting psychedelic access and innovation, Shams' work has focused largely on pre- and post-grant patent interventions and state policy advocacy. She holds a PhD in biomedical engineering and is currently a 2L here at UC Berkeley Law, and one of our best and brightest here at UC Berkeley. Finally, I have Tamer Todd. Tamer teaches courses on cannabis and psychedelics law and policy at Berkeley Law. She's an experienced attorney with expertise in policy advocacy, legislative drafting, statewide policy campaign strategy, regulatory implementation, and nonprofit management in the areas of drug law reform, marijuana law and policy, public health, and criminal justice. All right, so I'm going to kick this off just to set the stage a bit for everybody. So the big obstacle that we're going to be talking about here is Schedule 1. Now, very, very high level overview. Under the Controlled Substances Act, Schedule 1 drugs are defined by three criteria. And the most important one is the third one that seems to be really dispositive if you look at a lot of the history here, which is that there is no currently accepted medical use and treatment. And scheduling matters. A Schedule 1 substance cannot be prescribed for any indication. It carries the most severe criminal penalties for possession, selling, or trafficking. It imposes considerable limitations on research access, and business expenses for the drug cannot be deducted from federal tax filings. Now, I just want to take a pause here to say we often will talk about scheduling and not totally think of the implication, but one thing I really want to put an emphasis on here is we are potentially talking about putting people in prison for a long time when they're dealing with Schedule 1 substances. This is a really, really big deal. And when we're talking about taking people's freedom away, this is a huge barrier that needs to be overcome and very seriously considered by people. So next, I want to start this next part as a former biology teacher, and my brain often goes to thinking about things in kind of a biological sense. And I'll start with this quote by Louis Brandeis, and it is that it is one of the happy incidents of the federal system that a single courageous state may, if its citizens choose, serve as a laboratory and try novel social and economic experiments without risk to the rest of the country. So, the United States, we have a federalist a system where we have laws that will affect all federal laws, which will affect all 50 states, but we also allow states to try out their own laws. And sometimes those laws will conflict, as we saw with cannabis early on, and as we're starting to see with some initiatives in states like Colorado and Oregon, where they are starting to legalize or decriminalize certain psychedelic substances, while those substances still remain Schedule One on the federal level. And because, keeping in mind this laboratory theme, I always like to come back to this quote, which I used to teach my students, which is, in the field of observation, chance favors only the prepared mind. We're embarking on what I think is a really significant federalist experiment here, where we're allowing some states to try out providing access to these substances. And I think the best thing that we could be doing right now is to be talking through this, thinking through all of the potential difficulties, because, as Louis Pasteur says, chance favors the prepared mind here. So there are several routes to descheduling or rescheduling drugs. We're going to touch on all of these today, but the main two are this first one, which is administrative scheduling by petition. Basically, any interested party is allowed to initiate a petition for rescheduling. Now, this kind of a subcategory within that is this second one, which is FDA approval rescheduling. And this one is sometimes called the back door. But the key to this one is that FDA approval gives a accepted medical use, and that then forces the DEA's hand to reschedule these drugs. And so this is why you're starting to see a lot of movement and a lot of discussion about what the ramifications of FDA approval will be for different psychedelic substances. We also have congressional action. Congress put these drugs on the CSA. They're allowed to take them off. In theory, they could just pass a law. I'll just say I was researching this all weekend, and at some point I was just said, why doesn't Congress just do this? This is going to be so complicated. It would just be so much easier if Congress just passed that. Although that would be politically quite tricky. There are also state level approaches, which we'll talk about. States can reschedule or deschedule on their own. And what we'll see is what we saw with marijuana, where something can maintain its Schedule One on the federal level, but potentially be on a different schedule at the state level or treated differently at the state level. And there's also specialized strategies. We'll see if we touch on these today, but there's the right to try approach that others have taken. Religious and indigenous use exemptions have been tried, and other constitutional rights, such as the right to privacy or the First Amendment right to cognitive liberty, have been attempted to make this argument for expanded use access to psychedelics. Now, the kind of the big review path that I want to talk about is because it's going to be so heavily implicated, likely in the coming years, is this administrative review path, and this is the FDA backdoor path, where if something is approved by the FDA, it will then trigger that there is a currently accepted medical use, and the DEA is legally forced to move that drug out of Schedule One because, again, a Schedule One substance has no currently accepted medical use. And the tricky thing to keep in mind here, and this is hopefully we will touch on this a bit in our discussion, is that the DEA typically does not reschedule the raw substance wholesale. So I'll give a couple of examples of this. The FDA approved a drug called Xywav, which contains GHB, but it also has a bunch of other stuff. Xywav was moved off of Schedule One, but GHB, which is the key active ingredient in Xywav, was removed from Schedule One, is still on Schedule One. This also happened with marijuana and Marinol. Marijuana, one of the primary psychoactive substances in marijuana, is THC. Marinol was an FDA-approved drug, which is 100% THC. When Marinol was FDA approved, it was moved to Schedule 3. But quite famously, marijuana, which has THC and other things in it, is still on Schedule 1. The takeaway here is that the FDA or the DEA typically will reschedule only the FDA-approved drug product. That is what a lot of people expect to happen. It's not necessarily what they need to do, but it is what we typically see. This is called bifurcated rescheduling. Now, going back to our previous topic, right now we have a state law patchwork starting to pop up. Oregon has and Colorado have both passed laws that have expanded access to psychedelics. But the key thing to remember is that at the federal level, these things remain in Schedule One, meaning they are highly restricted. One of the ways that you might be asking yourself, why? How is this possible? How are these states allowing access to this? And a lot of this is just based on discretion. Congress has passed different laws saying you can't, some of these are housed in spending bills where they say you can't spend you can't spend any money on trying to prosecute these things, or it has to become a lower priority. But some of this is discretion, and some of this is the federal government just kind of waiting to see what happens. We saw this play out with marijuana, and we're seeing it play out with psychedelics. Now, I will just say that is, if you are someone who's trying this out, an imperfect solution, because again, I want to come back to this point that when we're talking about Schedule One, we're talking about potential imprisonment. We're talking about, putting people in prison for potentially a very long time if they are on the wrong side of the law on this. And so this creates kind of an uneasy status quo in the country where, people who are in a lot of these states where these substances have been made legal locally are still putting themselves at risk on the federal level. And then the next thing I want to talk about is if the DEA opts to change any of these substances schedule. So move, for example, psilocybin or MDMA off of Schedule One to a different schedule. We have two different types of states. Some states, I'm calling these coupled states. Those automatically conform to federal DEA schedules. So what that means is they basically say our schedules are whatever the DEA says. So when the DEA changes it, it's going to change automatically. We also have decoupled states, which are not linked to federal schedules. And a key element of this is we also have trigger bills, which are starting to pop up. And our panel will most certainly be talking about this today. And the way that these trigger bills work, in essence, is they say if the DEA reschedules this drug, then our state constitution is going to reschedule it as well. And oftentimes they'll do this for only specific drugs. They don't tag their entire state schedule to the federal schedule. They'll only tag a specific substance. We're seeing this play out quite a bit now for psilocybin. And I'll just note that there are two potential ways to do this. One is the bifurcated way, where you really carve out something that is the approved substance. The other is non-bifurcation, where you are only carving out, or where you are changing the schedule for the entire class. We'll touch a bit more on this, I'm sure, in our discussion, but just for everyone in the audience, a bit of a background for everything. All right. And I just want to end with this as we jump into our discussion. And going back to the states of the laboratory topic, there's a great, if anyone is interested in learning more about this, there's a great Columbia Law Review article on this. And this article actually challenges the states of laboratory, or it kind of interrogates that idea by saying, the states are laboratories, yes, but it's much more complicated than that. There are third-party organizations in these states that are really starting to kind of, they have a lot of the say in how this is playing out. And we're seeing this now in the psychedelic space, where there's a lot of third parties, whether they be advocacy organizations or nonprofit organizations or for-profit organizations, starting to steer the direction of everything. It's creating a somewhat complicated paradigm, but one that, from a legal standpoint, is going to be quite exciting and interesting to see play out. I'm going to open this discussion up with our phenomenal panelists. And again, if you have questions throughout this, I'm going to be monitoring the chat while we guide this. But I'll start with my panelists. So the first question I have is the FDA. I want to talk about the aftermath of the FDA's recent rejection of MDMA. So Ismail, I want to start with you. The FDA recently rejected MDMA assisted therapy. And I'm curious, from your perspective, Do you think that this was a failure of the trial data to meet the scientific standards, a failure of the FDA's standards to adapt to the unique nature of psychedelics? Should we be giving up on the medical approach altogether? Curious your take on this.
Yeah, a lot of good kind of questions that are woven together in there. I'll start by clarifying that I'm speaking on behalf of the MAPS nonprofit, not the drug sponsor, which in this case was Lygos Therapeutics, now known as Resilient. So just to clarify that piece, but obviously happy to share my perspective on this. And I guess I'll start by saying that when I'm having this conversation with folks right now, I have concluded that I am treating it more like a delay than a rejection. I think, when you look at the acute environment of the submission and then the outcome, easy to see as a rejection. But what actually happened was that FDA asked for more information. So I see this as like another kind of part of the long arc of this process, which in some ways has taken decades. So I think that as far as failure goes, I'm not quite ready to say that. I think that for the movement, it shows that it's important to diversify approaches to access and that medicalization, while important for um, certain contexts, in particular ones that where there are high comorbidities or high needs for the patients. I'm sure we'll get more into this, but there's a big conversation around like kind of larger spectrum of points of access, whether it's through decrim, adult use, regulated use, other approaches that maybe have similar, if not identical, goals. So I think that's one like larger lesson you could say. And I think for the industry itself, um, it really shows that new information is always coming in. The initial agreements that MAPS PBC, the public benefit corporation that MAPS spun out in 2014 to actually drive the drug development, the information that it was responding to kind of evolved over the course of the 2010s into 2017 when the special protocol assessment and the breakthrough therapy designation occurred. And obviously between 2017, 2019, and early or late 2024, a lot of new information has kind of gotten clear about what these trials ought to look like. And I think to answer your question more directly, it's a little bit of all of those things. I think the general unfamiliarity with the modality, the fact that there's elements that are outside of drug control itself that are actually relevant to the MDMA therapy modality, as well as some, I would say, like longer term or more known or legacy issues, you could say, with drug development more broadly, like blinding, things that are not unique to psychedelics and in some ways maybe unavoidable with a lot of psychiatric pharmaceutical interventions, but that kind of were brought back up in the context of this new paradigm. So I can say a little bit more about that, but all that to say that a lot of lessons have come in. And again, if I zoom out from the whole story of how MAPS specifically and other organizations within the field have attempted to bring any of these substances through the FDA process, it's just like a constant process of learning more. And I can say maybe more about the cannabis stuff in a bit, but I'll start there with the MDMA piece.
Thanks so much, Ismail.
Mhm.
Tamer, I'm curious your take on this. You worked with the New Approach Pack, which helped to create models in Oregon and Colorado that don't necessarily wait for the FDA. So, in your opinion, how wedded to the this medicalized route are we?
Yeah, I mean, I think in terms if we're talking about federal legality and a federal approach, I think we're extremely wedded to a medicalization model. I think the federal government really only conceptualizes treating drugs in two buckets. Either they're recreational and they're focused on the harm and addiction potential of those drugs, or they're medical and they're focused on whether or not they can treat disease. And I don't think there's space really in the structure that we have of federal drug control that sees something different. So I think when I look at it, I think in terms of achieving federal legality or some sort of federal protection, as at least in the near term, the route will really be through an FDA approval that probably leads us to something like you mentioned, Marinol, which is like a limited access and not a wider reform. I think on the state policy level, though, there's the potential for something much broader. And you mentioned in the beginning that Schedule 1 is really, really important. And in a lot of ways, it is really important and it messes up a lot of things and controls a lot of things. On the flip side, there's some ways that it's just not important. Like cannabis is still Schedule 1 on the federal level, and we have widespread state programs of access. There's stores on Telegraph right near Berkeley Law where you can go in and buy a regulated product. and it remains Schedule 1 federally, and in a lot of those states, it's still Schedule 1 under the state Controlled Substance Act. So it's important in some sense, but there's a lot that can happen in state policy reform. And I think in this context, we can see if we're going to see models that are not completely medical approach, that will most likely happen on a state level where there can be a space to conceptualize regulation of drugs for something other than recreational or treatment of disease. There's a possibility that we get more federal protection, like something like you mentioned the federal budget rider that protects some medical cannabis laws from at least federal enforcement, although it doesn't solve all the other problems that federal illegality creates. So maybe there's some sort of waiver or protection like that you get. But I think in terms of a federal route, we're pretty much stuck in a medicalized approach at this point in time. Maybe long term, if there's a big body of evidence developed through state policy programs and that's brought in a rescheduling petition, we get something else. But that's my thought.
I'm glad you brought up the Telegraph example. So I'm actually curious for both Tamara and Ismail. If I were to go to a dispensary right now, I would not really think twice. I wouldn't expect or fear that an FBI agent or a DEA agent would be there to arrest me after walking out, even though this remains illegal at the federal level. Could either of you see a near future where psilocybin MDMA remains Schedule 1 on the federal level, but is made legal at the state level, and where people can kind of access it similarly to how they can currently access cannabis?
I can. I'll say a couple of things. So, and would love to hear Tamara's thoughts, of course. One, just in response to what Tamara was saying, I would add that there is this kind of religious use category that the federal government holds, but what Tamara said is still correct because it's categorized as non-drug use, which is its own kind of characterization. So even if there is a Schedule 1 substance involved, the kind of environment, the legal environment in which it's considered is different. So, but just wanted to name that because it's its own conversation. And for what we're talking about here, where you're talking about treatment for an indication or really just personal use of any kind, I think that it would be more likely with psilocybin versus MDMA. One of the maybe key things that are similar here is that with cannabis, the possibility of like a fully enclosed, closed loop state program made sense and is possible because you can grow cannabis in a lot of places and you can move it fairly easily. And I think similarly to psilocybin mushrooms, once you get into the synthetics, the kind of additional layer of zoning, manufacture, controls, like there's a lot of additional things that I think would make that much more complicated. I can imagine a version of reality where there is legal access to something like MDMA in a non-medical setting and sort of an adult use regulated setting. And it would have to be, I think, much more complex than what we've seen with both cannabis and psilocybin. And maybe one other thing I will add is that the context of use, or at least the way that psychedelics have been described and kind of the way that the public is getting educated about them has a lot more to do with the sort of facilitated, guided therapeutic use, which brings this other element of people who are supporting in one way or another, which is kind of one other difference you could say between the two.
So I want to let's say that we stick to the medicalized route, and if the FDA approves a drug, and Graham, I know you work with Psychedelic Alpha, and if people go to Psychedelic Alpha right now and you check their tracker, you'll see that there are a lot of psychedelics moving through the FDA approval process. So let's assume one of those gets all the way through, gets the new drug approval from FDA. Shaheen, can you talk about some of the work that you've done with Porta Sophia and some of the potential issues you see with that route?
Yeah, sure thing. So just to preface this, Porta Sophia has only recently entered the policy space, and that's because we've been seeing an increase in pieces of state legislation coming up that have proprietary leaning language that isn't actually recognizing the totality of essentially the psilocybin therapeutic landscape. So Just to provide a little bit of background for everybody, so there's been a recent surge in a subset of trigger legislation that has emerged across several states that are focusing on either rescheduling or allowing legal prescription access to a form of synthetic psilocybin, specifically crystalline polymorph psilocybin. Vince, I think you had actually a snippet of one of those bills on your screen. So upon a FDA approval as well as DEA rescheduling, this version of this drug will be made allowable within the bounds of that state. 11 states have introduced such bills in just the 2025 legislative session. 3 have passed them into law. And one of those states also has an existing psilocybin program, but I won't go too much into that right now. So the issue that we have with this is that there's been a new trend of having proprietary patent portfolio derived language being included in state pieces of legislation. And we've been going to these affected states and been informing lawmakers of this, essentially this deficit that they currently have within that language, because every individual that we've spoken to that had their hands on these bills and very supportive of it was not aware of the fact that this actually had a proprietary lean to it, and it actually may result in the exclusion of other viable therapeutic options that are at the same stage of clinical evaluation as this particular bill's corporate sponsor. So this result of bifurcated rescheduling that would result from the passage of these bills, we aren't exactly sure of the long-term effect that this may have in terms of actual accessibility, right? So the individuals of the state, upon FDA approval of just this one particular version, will of course be able to have access to that one proprietary product. But say another version also gets FDA approval, given the fact that there's this like corporatized proprietary marketing term that's been included, it may or may not actually apply to other versions of this drug upon FDA approval. So that gums up the works from a legislative perspective, gums up the works from a court perspective, and it just results in restricted choice of individuals in the state that are simply just trying to find the best mental health care route that would be right for them.
Shaheen, just because we probably have some psychedelic novices on the call and some legal novices, just to really make sure that everyone understands this, can you walk through what is the exact sequence of events that you're looking to avoid?
Yeah, specifically at this particular point in time is that we're just attempting to ensure that upon FDA approval, DEA rescheduling, that these drugs will be made immediately accessible to the population of interest. It's essentially ensuring that individuals will not be facing restricted choice in healthcare options for them. So this essentially would be implemented once this law passes. It is going to be essentially sitting and waiting for FDA approval of whatever drug may or may not apply to it. And upon FDA approval, DEA rescheduling, then that drug will be made accessible, right? The issue is that if another drug around the same time in the future, literally in perpetuity, will be passed, there is still going to be an issue with the state scheduling laws, or even how the state is recognizing this particular drug of interest as to being something that may have therapeutic value or may not. And since we have a lot of states that do not have this sort of like coupled relationship with DEA scheduling, so federal scheduling versus state level scheduling, this could just lead to delays, significant amounts of delays. And also that means that individuals will be channeled towards a specific proprietary product, which typically does have a proprietary upcharge associated with it being a brand name.
All right, so I'm just going to tag this with, there's an organization called Compass, and they're moving their substance, which is called Comp 360, which is not just psilocybin. They call it Comp 360, and that's moving through FDA approvals. And Shaheen, is the problem that only Comp 360 is going to be approved, and is Porta Sophia looking to have, once Comp 360 gets rescheduled, you want all psilocybin to be rescheduled?
Precisely that. So Comp 360 is, again, this crystalline polymorph psilocybin. Essentially, it's a highly purified psilocybin version that is essentially a very specific three-dimensional organization of molecules that can impact solubility and bioavailability. But there are other versions of psilocybin that are currently moving through the FDA approval process. There are, I think, 13 registered clinical trials, and Comp 360, I believe, is the focus of 2 of those 13. So there are just a lot of other versions of this drug that may cross the line for FDA approval. Whether they're first, whether it's farther down the line, doesn't really matter. We just want to ensure that whichever one crosses that threshold, however many those are, then individuals in those states should have access to it. So what we're doing in these states, informing lawmakers of the current language problem, and also supplying a type of a language change that would just be recognizing the totality of therapeutic options, making it corporation agnostic, making it source agnostic, making it formulation agnostic. So not only would something like COMP360 be allowed, but the totality of all versions of psilocybin currently under clinical evaluation would be allowed.
Graham, I know that you've worked in patents for psychedelics, commercialization approaches for this. Can you help me to make sense of this from the commercial side? So if Comp 360 gets approved, don't we just, I mean, isn't that what bifurcation is? Isn't bifurcation just the system working as it's designed? Because only that one thing is approved, not all of psychedelics. Can you help me to make a bit of sense of this approach?
Yeah, well, I think maybe one of the easiest ways to make some sense of it is to maybe mention a story of how I started my legal career. I actually worked for about 2 years with probably 24 lawyers fighting over one drug getting 2 extra weeks of exclusivity because I think it was like a close to $10 billion a year drug. Every day of exclusivity was, many, many millions of dollars. So I think the goal here is if another company that wins approval after Compass, they would be in certain state markets, however many days, weeks, months behind in being able to launch their product. And in each of those markets, presumably there's some calculation made that the cost of lobbying those state lawmakers was less than the amount that they would make by keeping their competitors off the market for a little bit longer. I mean, that really is kind of the whole game with regard to like patents and the other types of regulatory exclusivities. It's just, companies are making a calculation. How much are these clinical trials going to take? I think the kind of company line now is, I think, even over $10 billion it takes to get a drug to market. You could probably question that a little bit, but even if it's 500 million, how are they going to get that if they don't have exclusive rights to sell their drug at the end of it? And once you do have exclusive rights, every day they can extend those a little bit longer is more money they can make. But I guess the other part of your question, isn't this how bifurcation is designed? I mean, I think you sort of suggested, although maybe you didn't underscore it enough, which is I don't think bifurcation is designed like this at all. This is just taking advantage of ambiguity or the flexibility that bifurcation can be used this way. I don't think there's anything that demands it at the federal level, like has happened for GHB and marijuana. And I don't think there's anything that demands it, certainly at the state level. I mean, I think as mentioned, the state legislators apparently didn't even realize kind of the effect that this would have.
So just to make sure I'm getting this all, there's this organization Compass, which has spent a lot of money on FDA approval for their substance Comp 360, and the kind of the argument, or they want to be able to recuperate those costs, and if we only will reschedule Comp 360, then that will help them to maintain that exclusivity and be the only people selling it and charging then higher prices to be able to recoup the costs faster.
Yeah, so I mean, presumably, as Shaheen mentioned, there's many other companies looking to get approval for psilocybin after Compass. If any of those get approval, and they're presumably would not have the same crystalline polymorph as Compass, which is patent protected, then they would also need to have, go through the process of having the same sort of descheduling, at the state level and at the federal level for them as well. So obviously, we just slow them down.
Yeah, Shane.
Really quick, it's actually also important to note that while there are a couple of different proprietary versions of psilocybin being evaluated, whether that be a proprietary crystal structure like COMP360 or even deuterated metabolites, there are also several trials that are focusing on just run-of-the-mill public domain versions of psilocybin that cannot be privatized or monopolized through patenting. So it's just important to also keep that in consideration when we're evaluating what versions of psilocybin will be on the table and allowed at the state level, because it essentially would ensure that kind of like monopolization activity isn't going to be as present as long as you have like a GMP facility that's able to produce high quality psilocybin. It may be a little bit more applicable for other providers to enter that space and also make it a more competitive pharmaceutical landscape that can drive prices down and benefit consumers.
Yeah, and maybe I should also mention too that the kind of harms I guess I'm speaking of now are really just like company to company harm. So another company looking to commercialize psilocybin, but this is not getting into whether or not psilocybin just itself should be taken off Schedule 1 so that others who are not in the medicalization route, not taking psilocybin through FDA, they won't have some of the the dangers facing them that you mentioned in the beginning, potentially, being arrested and being, subject of consequence of having a Schedule 1 drug.
Taking the position of someone who, is new to this field. All right, I don't like Schedule 1. And so it seems like the FDA route is pretty effective for that. All right, if I want FDA approval, I got to get someone to pay for it. So yeah, I don't love patents on psychedelics, but I gotta incentivize people to pay for it. So maybe I, need to do whatever I can to incentivize that. Ismail, I'm kind of curious your take on this. I know that you were representing the nonprofit side of MAPS, but I know that MAPS does also have a drug development arm that has taken kind of a unique approach on this.
Yeah, I have a few thoughts that are sort of kind of to weave together some of these points. What I'll start by saying is that there is another way, and actually, maybe two things. One, and I think Graham alluded to this, and so did Shaheen, but maybe just for the audience's context, speaking of the difference between these substances, it's probably important to mention, just to be crystal clear, that substances like psilocybin, ibogaine, mescaline are derived from plant-based materials, and there is, various forms of evidence of use in traditional and non-traditional contexts for a long time. And I bring that up because, to the point that you're making, Graham, the kind of initial premise that there ought to be, or that there is a patentable version, I think to Shaheen's point also, requires this additional kind of layer of specificity, right? Because the molecules themselves alone are in the public domain. And I think that's why you see this sort of crystalline polymorph and these sort of adaptations. So that's maybe one detail to share initially, which is that the reason that there's these variations being put forward and investigated is partially because the kind of base molecule themselves are very much in the public domain. So that's one thing. And then the other is related to the kind of different approaches for the opening up of the pathway in the future. So for example, in the years probably 2021, 22, 23, when MAPS Public Benefit Corporation, the name of the drug development company at the time, was looking into this issue, a lot of this had just happened with GW Pharmaceuticals and Epidiolex. So there was this process that already had to get gone through for what in that case was CBD, which was before it was controlled in the way it is now. And we noticed that when we were looking at all these different state laws on the kind of state federal parity or triggering or lack thereof, almost every state does it in a slightly different way. So whether the legislature is making the decision versus the Department of Consumer Protection versus the pharmaceutical board versus so each state, many states have kind of different mechanisms for making the decisions in the first place around whether or not they maintain federal parity or make their own decision. And the reason that's relevant is because what is actually possible, how big of an aperture you could create, you could say, depends on how the law is written. So when we worked on a bill in Colorado, for example, there was no way to craft state law to ensure that, let's say, every psychedelic or every Schedule 1 drug would automatically have parity at the state level as it did at the federal decisions were made. So in that case, we had to focus just on MDMA, and we passed a bill in 2020, I think it was 2, that basically created this future opening for any MDMA-based drug product. So that could be one that eventually maybe has additional adaptation on it, or anything that's like using, let's say, a generic MDMA. In a state like New York, where a similar bill was passed, the difference was between the word may and shall. It was like literally a high enough level kind of framework that the legislature didn't necessarily need to look at every single molecule every single time something is passed, and they're just a mechanism. So shifting it from the state legislature having the option to align with the federal scheduling, or the requirement to, was like, so I say this all to say that there's kind of different directions in which this issue can get responded to. And I think that does impact the strategy, that does impact what's possible. And big picture, I would say that the bigger the aperture, the more the fewer steps there are for future drugs to get approval and then have access. From our perspective, the better.
Great. I want to pivot a bit to learning from the cannabis example. Cannabis businesses right now, again, for everyone in the audience, cannabis is Schedule One at the federal level. Cannabis businesses, because of that, face very high tax rates and often can't have access to banks because of that federal Schedule One status. Do you think that state level psychedelic models create the same legal conflicts? Tamer, I'm curious with you because I know that you've done work with that with New Approach. What are the issues that some of these businesses might face, and kind of what are some lessons that can be learned from cannabis moving forward?
Sure. I mean, in terms of for the business and the tax structures you mentioned, it's actually the exact same issue. So for folks on the call who don't know, there's a federal tax provision called 280E, and it prohibits standard business deductions from any business or entity that traffics in a Schedule 1 or Schedule 2 controlled substance. So as long as any of these substances are Schedule 1 or Schedule 2, a state level licensed business that is directly involved with the substance in some way won't be able to deduct any of their like rent or payroll or anything like that. So it can be a big problem. So the legal issue is the same. I think potentially in this space, depending on what the state regulatory model looks like, it's even potentially worse, because the one thing, ironically, you can deduct is the cost of goods sold. So like for the federal law, actually lets you to deduct the cost of like creating the cannabis, even though you can't deduct anything else about it. In some of the regulatory models, like in Colorado and Oregon that we've seen, the substance itself is actually a really small piece of like what the business as a whole is doing, and the delivery of care and guides and therapists and all these other pieces that are part of the process. So your cost is large. I think the lessons learned, there's a lot of smart lawyers working on this in terms of how to structure businesses to break apart pieces. So you have as little in a business structure dealing with the substance alone, and you have other pieces separate. I think there's a lot of things that you can do about it, but and also in crafting the state laws and how you set up the licensing for the different pieces. I think it represents the larger problem of having a state model when it still remains federally illegal. This tax piece is one little piece. There's all sorts of other pieces involving all the federal regulation agencies that they do, the environmental laws, health and safety laws, all sorts of things, even, and then of course the federal illegality of what everyone is still engaged in on these state levels. But those legal issues are actually very applicable and almost directly the same, because you're still dealing with the federally illegal substance, and the sort of havoc it causes on a state regulatory program.
Graham, I'm curious your take on this. I know that you've worked a lot in the innovation space. Can a federally illegal business model ever be really sustainable? What are your advices for people that are looking to really create sustainable, innovative businesses in this space?
I mean, it requires an awful lot of optimism about what the federal government is going to do. I mean, the federal government certainly has taken actions lately, I mean, not related to drugs potentially, but relating to other things that we may have never imagined they would do. We probably have short memories with regard to cannabis, but in the Bush and into Obama administration, before to get into too many technical terms, but like the Cole memo that said the federal government was not going to go after state legal businesses. Before then, I mean, there were hundreds of raids on dispensaries, and people were constantly in fear of their businesses being shut down, and they may think otherwise now because cannabis is everywhere. But all it takes is one decision up top to change the the sort of priorities of the federal enforcement apparatus, and that can be very different. But I mean, certainly, I suppose the people who are involved in building these types of businesses are optimistic enough and are dedicated enough to its importance to want to continue.
For the audience, I have one more question for the group, and I'm going to open it up to questions for the audience. So while they're answering this one, please feel free to put questions in the chat. But I want to talk. This sounds like it is a very complicated paradigm, and as Graham said, it might require some optimism looking ahead. But I do want to look ahead. So let's say we're fast forwarding to 2030, 5 years ahead. What's more likely? What's more desirable? Federal rescheduling with states conforming through trigger laws. So the federals, maybe that's through the medicalization route. Continued state by state patchwork, where it kind of similar to cannabis, where we see it remain on Schedule 1, but we just try it out at the state level, kind of on the laboratory sense. And what should advocates really be prioritizing? What seems like the most winning argument if you want to expand access safely for these things? I'm going to go Ismail, Shaheen, Tamer, and Graham. So in that order.
Cool. Also, a bunch of great questions. I'll start by saying that it probably is worth mentioning that in the last, I was thinking about this, Vincent, when you mentioned that about not being worried about anyone kicking down the door of a dispensary in Berkeley. I do think it's important to flag that the administration and Congress, just in the last 4 or 5 days, have gotten much more serious. There's the potential of an additional national restriction on hemp-based THC products, as well as guidance around re-increasing federal prosecution for simple cannabis possession. So I'm just saying that because I do feel like while all the things we're saying about this larger arc and timeline are true, it's interesting to see the kind of constriction that I think has been happening even just very, very lately around it, even while we do see potentially good signals from HHS with respect to psychedelics in particular. To answer your question about 2030, I would say maps as a whole, and me personally, follow this sort of lots of on-ramps, lots of off-ramps kind of approach. And what I mean by that is I think that different frameworks are really viable for different kinds of people, different populations. So ideally, I think we would see federal approval through a medical route so that you have the entire kind of quality control system of pharmaceutical access available for people who need that or who are seeking that kind of support. And I think, again, while this may be much more complicated for synthetic substances like MDMA or LSD or others, certainly for plant-based substances, because of the fact that they're literally plants or fungi in some cases that can be grown, I do feel like having broad permission for adult use, personal cultivation, community use would be ideal, as well as some level of actual kind of complete decrim. And I don't think that these are mutually exclusive. I think that like I said at the beginning, there are different contexts that are best for different people in different environments. And I think ideally we would see a sort of continuum of care where there was actually a relationship and even communication between state regulated programs where people may or may not be cultivating their own substances or medicine, as well as these federal systems that probably require much more professionalization, much more due diligence and kind of support for the people that are going through that. That doesn't solve all the questions, right? Because it's kind of like who decides, how do you make the decision about where people go? What other mechanisms safety nets need to be in place to make sure that if there is a kind of an expanded level of access, that the additional risks that come in are also being mitigated. But I do think that it's reasonable and possible, although there are very, very, very few, if any, examples besides kind of cannabis where you see versions of this, where you have a pharmaceutical drug product that's approved and has that is accessible through that framework, as well as somewhere else. Like generally speaking, it's one or the other. And even in the examples we were giving with cannabis, Marinol, Epidiolex, Dronabinol, those are all kind of either derivatives or extracts. And I think that's different from, the pharmaceutical access to flower, the kind of thing that cannabis flower that you might buy in a dispensary. MAPS did receive a $12.5 million grant from the state of Michigan some years ago. And we are in the process of studying smoked or vaped cannabis flower through the FDA process. But I think that outside of this sort of botanicals, FDA is really set up and the system is really set up for single molecules. And I think those are the ones that are going to be more easy to get through that system. If and when, all these other details get figured out.
Right. Well, first and foremost, myself, as well as my colleagues at Porta Sophia, are scientists, not lobbyists, not policy experts. So we're kind of getting thrown into a deep end of the pool, sort of in education as to how to operate or orient ourselves in the policy space. So I'm going to avoid going from like a prescriptive side of what may be best, but I can provide a little bit of feedback on this. So from our experience, we've seen that every state has its own legislative nuance and its own legislative culture. So we don't want to tell lawmakers how to specifically do their job or to pretend what's best for them to do just so that they can do right by their constituents. So we're trying to meet them where they are in order to help them make more informed decisions on the pieces of policy that they're considering right now. So what's important, particularly at this point, as the landscape seems to be moving to some form of federal approval, is that as pieces of legislation are being introduced that recognize therapeutic relevance of psychedelics, medicalized or not, that corporate interests do not contaminate that legislative process with gamesmanship at cost of freedom of choice by state residents. So, for example, in just the 11 states that have limiting trigger legislation introduced around psilocybin, more than 60 million residents are at risk of restricted access and face uncertainty as to what FDA-approved versions of this drug their state would actually allow them to access. So working to change the language of corporate-leaning legislation to reflect the totality of the therapeutic landscape of these drugs to facilitate patient choice should be one priority that I think advocates in this space should consider moving forward.
Yeah, so I mean, I was looking at the question, and it focuses on which is the more desirable pathway, but I think it begs the question to what end, right? Like it depends what your goal is. And so assuming that the goal is, I guess, what I want, so I'll answer from that perspective, which would be both, pharmaceutical access for very specific purposes, as well as broader access and reduction of criminalization. I think both are necessary and essential. And I think for there to be a non-medical pathway and for there to be a non-substance component to the therapy or the process, it's essential that state policy reform happens. Like that piece is going to happen on the state level. States regulate professional practice and therapeutic practice and all those pieces. The one thing I'll say about which happens first is I do think that state policy reform will lead to federal reform, like it has with, cannabis. It's taken like 20 years and we're slowly getting there for things opening up. I think the pressure of states moving forward, they can do a huge amount because the vast majority of drug law enforcement happens on the state level. That changes people's perceptions. It pushes the law, it pushes the federal government for broader reform. I don't think the reverse is true. I think federal reform could happen. There could be approval of certain compounds for certain narrow conditions, and that does not lead to wider state policy reform, and maybe in some ways undercuts the will to do it in some states because people say you can have it for this or the other. So I think they're both necessary for the ultimate goal, but probably focusing on state policy reform gets us both, whereas I think focusing on federal reform just gets us a piece.
Yeah, I think the focus on the goal is the way to approach this question too. And coming at it personally, since I'm not bound to, I guess, speak on behalf of anybody else, I can certainly say that like my goals are not very well captured by the medical route or by the religious route, which seem like the main two routes through the federal pathway. And I think your slide at the beginning with the states being, laboratories of democracy or whatever it is the best way to underscore how the states will be, I think, the kind of the only way to get as many possible approaches to, so people having the, I guess, the ability to like have psychedelics be available to them outside of just those pathways. So I think, well, trying to see what else I can add, but besides what's already been added here, one other point I think that maybe just for like where efforts could be focused, I remember hearing that like the effort to bring Measure 109 through Oregon was like something like $5 million, and I forget how much I sort of said bringing a new drug to market would be, but obviously it's far more than that, and just the amount of money that's been spent on all the different psychedelic startups and all the different, sort of drug development efforts, like far outweighs the amount of money that could be spent on a lot of different state advocacy efforts. And one might argue, I would argue, could do better good than spending that money elsewhere on, on drug development and the federal pathway. And I think the federal pathway will sort of, fall into place in time. Maybe I'll kind of end with that then.
Great, thanks so much. We had one question come in the chat, which addresses the thing that I actually think would be really great to end with. And that is the chat asks why we haven't mentioned LSD. And I intentionally didn't define psychedelics early on, which is kind of an interesting problem in this space. I'm often wondering, like, what is a psychedelic and who gets to determine that? I wonder if the group has a take on that and how that kind of implicates this discussion as a whole. What is a psychedelic?
I can give it that. I think that the reason you didn't ask that question is because we would have spent the last 57 minutes just talking about that. In very short, the term means mind manifesting, and it refers to a category of substances that create physiologically or psychologically non-ordinary states of consciousness. And where the line is drawn really depends on a lot of factors. Is it because it impacts the 5-HT2A receptor? Is it because it has some sort of visionary effect? Is it something else? And it's true that it's a bit of a line drawing exercise, but just speaking to LSD, what I can say is that it is true that LSD, or a proprietary LSD based molecule, because LSD can be patented, is being developed for a few different indications. So similar considerations would apply to what we're describing, but it's further back relative to MDMA and psilocybin. Although I think because it's a synthetic, it would look more like MDMA than psilocybin from like a regulatory operational infrastructure perspective or like logistical perspective. There's also questions about whether or not the modality would be more difficult to implement because of the 12-hour timeline versus 4 or 6 hours or so on. That's its own whole conversation. But it is very much in the mix here. And I would say, just to add the other end of the spectrum, there's also conversations around especially 5-MeO DMT, which is more like 12 minutes than 12 hours. So there's the amount of time something takes. All of this is like one of the, all these are factors in, I think, the kind of commercial case and so on. But I think for the sake of this conversation, we're talking about the Schedule I substances that I think are generally considered hallucinogens, technically speaking, under the law, and then have all these like kind of range of effects and potential therapeutic benefits. So.
Thanks so much. And I do agree. Yeah, it would have been potentially a very long conversation to have that, and potentially a talk for another day. Kevin, you also asked, Kevin in the chat asked a great question. I know that we're at time, so I'm going to have to close this off, but I will just say, he asked a question about how to make this affordable, which I think is a great next discussion for this. So everyone, please be on the lookout for our next panel. And everyone in the chat, please join me in thanking our fabulous panelists for this. Thanks everyone for joining.
Thank you so much, Vincent, for the questions. Really glad to join you all as well.